Good afternoon, everybody. Welcome to yet another session on cooperative housing societies, realty and cooperative societies and what happens to people has been in the news thanks to Campicola. We are really honored to have someone like Mr. Vinod Sampat, who is extremely forthright in his speech. Now we go on to the session. Before we start, I'm going to ask Devashish Basu, my fellow trustee, to introduce Mr. Vinod Sampat. Thank you.
Good afternoon, everybody. I have the great pleasure of introducing today's speaker, Advocate Vinod Sampat. Mr. Sampat is the President of the Registration Fee and Stamp Duty Payers Association and the President of the Cooperative Societies Residents and Users Association. He's also an advisory member to the Federation of Accommodation Industry of India and Maharashtra Chamber of Housing Industry. He was among the earliest to oppose the compulsory registration of flats in 1994 in the manner it was done, and after he pointed out several irregularities in the Bombay Stamp Act of 1958, the authorities had to rectify some of them. We are all burdened with a variety of regulations and we have to comply with them as members, residents of cooperative societies, but have very little knowledge of such matters. We are really looking forward to hear from you, Mr. Sampath, to clear the confusion on such issues. Ladies and gentlemen, please give Mr. Sampath a very big hand.
Sucheta Dalal, Devashish Basu, other dignitaries of Moneylife Foundation and friends. I'll be speaking on cooperative housing societies, the weapons the critics have, conveyance and the common mistakes that are found in cooperative housing society. Friends, a point of time comes when one is not satisfied and likes to sit on the other side of the bench. Critic is a person who many times is intimately involved with the society, yet he utilizes it in a negative manner, not for the welfare of the society, but to show off his importance. My personal view is most of the problems in many spheres of life arise on account of ego. And I appeal to one and all, try to see things not from your point of view alone, but from the other person's point of view alone also. That will show you the real solution to the problem. And believe me, friends, it is very easy to criticize. I have devoted this particular PowerPoint presentation specifically for the cooperative society office bearers so that they can take precautions when they start taking interest in resolving the issues. Some things are done knowingly, some things are done unknowingly, but my experience is cooperative housing societies do not want to follow the laws of the land. That is what my experience is. First, I am taking you to the topic of the complaints against the builder, because all of us have spent substantial amount in purchasing a flat. We have intimacy, it's our prized possession. And after paying money, some of us feel cheated. Campicola is an extreme example how literally some flat purchasers have become landless, homeless for no fault of theirs. Not to mention the fact that crores of rupees have been taken as fees by lawyers. What was the reason that a scam of such huge level could originate? Sad it may seem, the government has always favored the bureaucrats. The concept of accountability is almost alien in government departments, because if the authorities try to take out 2 skeletons, that officer, like a critic, will say, if you take out my 2 skeletons, I can take out your 10 skeletons. And everyone knows that silence is golden. invariably, whatever may be the tall claims being made, but government officers, by and large, are protected by the very department. The law stipulates that the property has got to be conveyed within 4 months from the date of formation of a legal entity, which in many cases is the Cooperative Housing Society. The law stipulates that the builder cannot give possession of the flat until occupation certificate is received. The law stipulates that the builder is supposed to obtain the building completion certificate. The law stipulates that original documents of title to the property have to be given by the builder. The law stipulates that the audited statement of accounts have to be given by the builder to the cooperative society. The law stipulates that various registers have to be maintained by the builder, including the register showing the name and address of the flat purchasers, including the investors. The law stipulates that agreements have to be executed as per the model agreement. Model agreement is a part and parcel of the Maharashtra Ownership Flats Act. There are certain clauses which are compulsory in nature, like mentioning carpet area, mentioning the percentage of the undivided right, title and interest in the common areas and amenities appurtenant to the premises. Explanatory note 2 is very important, which stipulates that supposing there is a landowner A, he sells the property to B, B in turn sells it to C, and finally we have the developer D who enters into agreement with the flat purchaser. Explanatory note number 2 clearly stipulates that the builder, the developer is duty bound to make the earlier chain of document holders, the owners of the property, as confirming party. As you know, these builders are alien to complying the laws of the land. I ask the people present here, occupation certificate, building completion certificate, original documents of title to the property, audited statement of accounts, agreement in the format as laid down by the Maharashtra Ownership Flats Act. How many of you can vouch for the fact that your builder has complied with these statutory obligations? Will you please raise your hand if a few persons feel that your builder has complied with the laws of the land? I can see 2 hands being raised. The point I am trying to make is, by and large, in a small percentage, the builder complies with the laws of the land. We have still not gone into the at the micro level of those things, but by and large, the point is, why are builders, after taking such a huge amount, not complying with their statutory obligations? It's not that it is the fault of the builder alone. Clap can never occur unless there are 2 hands. And here I will say there should be 3 hands, one of builder, one of flat purchaser, and one of the government authorities. We as flat purchasers are ourselves greedy. We want shortcuts. We want to entertain the concept of speed money. We want instant results. And like a businessman delivering a product, similarly the builder is also exploiting these things. And when things go out of our hand, we blame the builder. I have nothing against any builder as such, but all I am requesting all of you is, always deal with a good person, a person who will stand by you in times of crisis, and the quantum of wrong that is being done should be to a certain extent known, and you should be able to solve it. Let's take an insight into property laws. When you go in search of property. We look at the beautiful designs, the beautiful brochure being printed, sales girl attending to you, sweet talks. But how many of us look apart from the cosmetic things, like let's go to the root of the thing. I will always advise you, friends, to go for freehold property. Properties can be freehold or leasehold. Freehold is you are purchasing a thing with no restrictions. You are literally the boss, you can deal with it in a manner as deemed fit by you. As deemed fit by you. You have to ensure that the title of the property is clear and marketable. If it is not a freehold land, the property may be a leasehold land. Earlier, we had long leases, 999 years. Then that period was cut and we found leases being executed of 99 years. Thereafter, government authorities felt that 99 years is a big time, so they cut it, and most of them was made of 60 years. We have BMC, which now gives lease only for 30 years. We have Bombay Port Trust, who also owns many lands, and they are renewing the lease only for 5 years. There is a lease deed. We should read that lease deed. What are the terms and conditions of the lease deed? Those terms and conditions will be binding on us. If we don't pay the lease deed, our lease can be cancelled. It is a sword hanging on you. For example, you are staying in a building. The building is on lease and there may be some conditions that you cannot redevelop the property. So for that you have to pay a cut to the lesser. So the next time when you think of purchasing a property, I think it will be appropriate if you inquire and give preference to freehold property, though it may be slightly costly. Now let's plunge into the things which are normally going wrong in cooperative societies. As I mentioned, our interaction with the property starts with the builder. And if the builder has not complied with the laws of the land, obviously one should not take it lightly. Many innocent flat purchasers have paid money for car parking, open parking, stilt parking, open terrace, garden area. If you look at the provisions of law, when a flat purchaser is purchasing flat, he is paying certain amounts for the common areas and amenities appurtenant to the premises. The implications of the same is each and every purchaser has paid money for car parking, open space, open terrace, garden area. If I have got a flat on 6th floor, I am bound to use the staircase or the lift and reach that place. I have paid money for that staircase. Similarly, for the parking space I have paid. So I have got a right to park my vehicle. It is not correct on the part of the builder to take some money from a particular member and give that parking space or terrace exclusively for his right. That is wrong totally, and law does not support such instances. When you find such instances where builder has violated the laws of the land, you as an individual or as a cooperative society can take the builder to task. And the best way of taking him to task is to approach the consumer courts and the criminal courts. We have seen consumer courts taking action against the builders. In a number of cases, huge amounts have been awarded as fine. I am sharing with you my case a few days ago which we got of Malad Evergreen Cooperative Housing Society. The courts, while granting conveyance in favor of the legal entity, were pleased to direct the builder and the owners to pay expenses of 65,000. In addition to this, till the property card is transferred and the building completion certificate is is received by the society. After 6 months from the date of order, fine of rupees 500 per day were levied. Similar orders have been received in the case of Natalia Cooperative Housing Society and some other societies. This is the power of consumer forum. And now the authorities are speeding up and in principle have already appointed a regulatory body which is waiting for President's sanction. And let me tell you friends, the day this sanction is received, it is practically a black day for the flat purchasers. They won't be able to ventilate their grievances in a proper manner, irrespective of the facts that tall claims are being made that it is very good. Criminal action against the builder is literally out. I am telling a personal authority is appointed, but that authority is without power. It is a toothless authority in my view, and repeatedly I am emphasizing, what can this authority do if it is not provided the proper infrastructure? It is not provided with funds. तारीख पे तारीख के अलावा कुछ नहीं होने वाला है. Because for the whole state of Maharashtra, hardly 1 crore rupees budget is given for 5 years, and after that it has to fund by itself. Rosy pictures being made that this will be done, this will be done, that will be done. But what is that 1 crore rupees for 5 years? It is not going to solve anything. If you go for a small infrastructure, lease rent, salaries, these funds are not even the tip of the iceberg and they won't be able to function. What will be the amount of salaries? It is going to die its natural death, only time will tell. And the builder will literally go scot-free because he wants to delay the matter. And there are so many clauses which are against the interest of the flat purchasers, and politicians have literally fooled the members of the public, is my humble submission. I will come to that part a bit later, how they are playing the games. As far as a critic and a cooperative society is concerned, common mistakes which we find in societies is a system is going on since a number of years. A particular member is parking the car. He claims that he has paid money to the builder. Builder normally does not execute an agreement, but he simply gives a letter of allotment after taking his money, mostly that too in cash. So he claims a right, but legally he does not have a right. How many of you are aware that even your friends, well-wisher coming to the society are entitled to park their vehicle in the building premises? Every society in the earlier years had to allocate 10% of the parking space for visitors. Now, because of shortage of parking, in new buildings, that space in Mumbai city has to kept open for visitors, compulsorily 25% of the car parking space. And I have no hesitation in saying that a small percentage of the societies may be having this sort of facility, but in rest of the societies, the members themselves are not able to park their vehicles in the building premises. So when you look at it from the law point of view, your visitors also are entitled to have the parking space. Leakage is a 24/7 problem. Whenever a leakage occurs, literally there are two groups in the building. One group is of the residents on terrace and the upper floors below the terrace, who are always in minority. The line of action of the members is, our maintenance is 2,000 rupees, and some gentleman, a member of us, is saying that we'll have to spend 5 lakhs rupees on terrace. Why should we spend that money? If he is keen, let him spend that money. So obviously leakages are ignored, and water always finds its own level, If there is a leakage, water is bound to come down and it will percolate till the last ground to the ground floor. So it's only a question of time when the building's life gets affected, and in the long run all members have to suffer. The magnitude of suffering of the persons residing on the upper floors is more, which they feel are literally helpless. There are remedies available. Action can be taken at the BMC level, at the consumer forum level, at the police level. But by and large, because the amount involved is not very big and one does not have the time to run about, normally compromises occur. A percentage of the repair expenses are borne by the persons who are the actual sufferers, and certain percentage is shared by society. But strictly speaking, in the eyes of law, these things are not permitted. It is society's responsibility to get the things repaired. If there are, say, 5-6 members who are suffering, a better approach will be one member approaches consumer court, one member approaches police, one member approaches BMC, one member approaches cooperative court, because all these authorities have got the power. And if the same member approaches different authorities in his personal capacity, then they will say this is a thing which we cannot do because it is already a subjudice matter. Other wrong things going on in the society is greed. When the matter comes of transfer, cutting across the views of the members, a syndicate is formed, and the law clearly stipulates that 25,000 is the maximum sum that can be collected as transfer fees. But there are instances where lakhs and even crores are collected as transfer fees. Similarly, when a flat is to be subletted, the law is very clear that 10% of the amount should be collected as non-occupancy charges, and these laws are normally tossed and huge amounts are collected. Magic words like renovation of passage areas, inconvenience caused to security staff, repairs expenses, administrative expenses are to be incurred. But in the eyes of law, non-occupancy charges cannot exceed 10% of service charges. When you purchase a flat, within 6 months from the date of formation of the society or being admitted as a member of the society, it is the duty of the society to issue the share certificate. But many times, knowingly, these things are not done. Specifically, if the member has done some unauthorized construction or someone wants to harass the new person, force him to surrender his car parking or something of those sorts. Similarly, a cooperative society has no right to charge huge amounts as deposit for allotting car parking space. One more weapon for the critic is he is having a bat. The ball may come from any direction. He can hit left, right, and center. Somewhere down the lane, someone is going to be caught. When we look in terms of numbers, let's assume there is a society of 50 people. Juvenile Workers Act stipulates that neither the cooperative society nor its members can employ minors. How many houses are there who are not employing minors? The answer is very few. And the penalty is 20,000 rupees or 1 year fine, or both, at the discretion of the authorities. Up to is the penalty. So, if there is a critic, he has some knowledge of the laws, he can exploit these provisions. Basically, managing the affairs of the state is not the responsibility of the secretary of the society, but because the cooperative sector does not have a voice, these things are literally misused, and all responsibilities, be it election-related responsibility or ensuring that laws are being complied with, all these things are being put on the managing committee members. We look at the flats, and wrongful acts are omnipresent in societies, buildings. Bombay Municipal Corporation has wide powers. The wrongful acts of the BMC will be taken up a bit later, but if there is a member, a critic, he can safely initiate action against the society's office bearers and members, because some members must have broken the common wall leading to balcony. Some member may have changed the position of kitchen WC, amalgamated the two flats, or shifted a wall. Action under 351, 354A, 381, 475, 475A, etc., as well as Maharashtra Regional Town Planning Act 52, 53, 1, 55, 56, etc., can be initiated, and it can be disastrous. Societies normally are not covered under service tax sector because they are not rendering service. But if the collection from the members is more, definitely service tax has to be paid. Property tax, etc. items are exempted. Big societies, posh societies may have to pay service tax. And critic can also take up these matters. One idiotic law which has been incorporated in the Cooperative Societies Act is Rule 107B of the Maharashtra Cooperative Society Rules. The intention may be noble, that a person who is handling cash of the society should give security to the society. But the authorities have got a very narrow vision, according to me. If I am a member of the society, if I am having a flat in the society, I am looking after the finances of the society as a treasurer. I am told that I will have to take insurance and I will have to give security to the society of a few hundred rupees. If I want to do something wrong, I will certainly not do a wrong of a few hundred rupees. I will do a big wrong only. And my society, I have got my flat. So if anything happens, society is not going to transfer my flat. What is the intention of the authorities of taking a small amount as security? It is nothing but giving a weapon to a critic to harass a chartered accountant for professional misconduct. My personal view is professionals are very soft targets. In life, you have always to be afraid of retired persons because he has the wealth of time. And nobody can beat a person who has got the wealth of time. Because for them, killing time is an activity which they want, and society provides number of occasions to utilize this productive time. In the first instance, even in their house, many family members prefer that he should go out. Youngsters may be going to office, but the secretary will literally hold them to ransom for 5 minutes and then only allow him to go. And the common topic is you don't know what is happening in the society, how your funds are being misused. At times, police do not record the complaint. The best way is first send a complaint in writing to higher ups as well as senior inspector, and if there is no response, immediately approach the magistrate under 176(3) of the Criminal Procedure Code. Government officers do not respond. Write a complaint, follow it up with RTI. My view may not be liked by many, but if you want to get results, you should know how to get results. It may not be legally correct, or I will say rather morally correct. It may be legally correct but not morally correct. If you have got your family member or well-wisher say 500 kilometers away, you file one complaint, you file two complaints, and your well-wisher files another complaint, same identical wordings, 500 kilometers away from the place where the cause of action is arising. We have Mr. Devashish Basu here. He has got quite a few relatives in Calcutta. So he can safely tell one of his friends or relatives to file the same RTI in Bengali language. And from Bengal, that registered AD of the RTI application is submitted to the Bombay office. Obviously that officer may not know Bengali, or even if he knows Bengali, he may not take that complaint seriously. But because 10 rupee has been paid on that right to information application, the person making the application becomes a consumer within the meaning of Consumer Protection Act. And by not providing information, this amounts to deficiency of service. So if some person from faraway place files one RTI application, sends the registered AD from faraway place, this officer sitting in Bombay may have to attend the courts at faraway place as of date, as per the prevailing laws of the land. And believe me, if once or twice these things are done, the tone of the officer will certainly change. This is what my personal experience is there. I have done it myself and I have got very satisfactory results by utilizing these things. It may not be morally correct, but as far as results are concerned, that is important, is what I always believe. Many times your advocates are taking you to task, not giving you proper information, evasive replies are being given. Here I will tell you, please insist for a copy of the Roznama. That will give you some insight of what has actually transpired on the date of hearing. Judge A is listening to your petition today. After say 6 months, Judge B comes. He will not start everything afresh. He will just go through this Roznama page and make up his mind at to what stage the matter has reached, and whatever queries is there, definitely he will ask. So when you have the official copy of the Roznama certified true copy, you know how the matter is proceeding and important submissions are recorded in the Roznama. Normally you will get a reply that judge was not sitting, court is not sitting. If the court is not sitting, the judge has not come, your advocate has got a right to take up the matter with the court which has got additional charge. It makes no difference to you whether Judge A hears the matter or Judge B hears the matter. But do insist on taking up the matter fast. There is also a High Court circular dated 3rd August 2009, which stipulates that because senior citizens have contributed a lot to the society, their matters should be heard expeditiously. The power is given to the judge who is hearing the matter. There is not a blanket right. But certainly, if you are a senior citizen, you have every right in Maharashtra to point out to the trial court that I am a senior citizen, this is my proof of my age, and please expedite my matter, make a miscellaneous application that can help in getting faster justice. Many quasi-judicial authorities close the matter, even ministers. They will hear the matter but they won't pass the orders, and these things go on for a long stretch of time. Order 20, Rule 1 of the Civil Procedure Code is very clear that normally once a matter is closed, within 1 month the order should be passed. So the next time you face such a situation, you can tell the courts by application that kindly please look into it and pass appropriate orders. Bombay Municipal Corporation, many are tempted to call it bachelors and masters of corruption. In fact, one of our ex-chief minister always called the standing committee as an understanding committee for the betterment of the corporation. Because if corporation is better, some others will also become better, be it in the nature of the type of services or the facilities that is being obtained. Are you aware that the budget for the Bombay Municipal Corporation for the year 2013-14 is 27,578 crores. And what you get in return is 4,578 cell towers which are illegal, 9,500 plus files lost of building proposal department. I am told that for one file to get the occupation certificate, minimum amount demanded is 1 crore, minimum. This is what I am told. 47% of the societies who have applied, 47% of the buildings who have applied have got the occupation certificate. That means out of 100 buildings which have been constructed, only 47 has got occupation certificate. This is for not one particular year, but 2003, 2004 to 11-12. And only 7.97% have got the building completion certificate. So out of 100 buildings constructed, not more than 8 buildings have been constructed as per the law of the land, is what BMC has themselves told in the right to information application. Is it not amusing that the driver is getting more salary than our municipal commissioner? But these are the facts. The driver gets more amount than a municipal commissioner and IAS officer. It's really unacceptable. If the BMC appoints drivers on contract basis, definitely I don't think so a driver may be charging more than 2,000 rupees a day if he is appointed from a private party. But here the salary of the driver is more than that of municipal commissioner. Same is the case with our corporators. Their lifestyle, what was earlier and after becoming a corporator, I leave it for you all to guess. Not to mention the criminal cases that are filed against our corporators. We are literally cursing BMC for levying huge amount as property tax. And believe me friends, if BMC has it in its ways, I will not hesitate to say that more than 10% of the population will go away from Bombay because of property tax. People are not understanding the implications of the increase in property tax. At Nepean Road, the projected property tax per square feet is 225 rupees per month. This is what is the figure at Nepean Road for commercial premises like banks. Beer bar pays less property tax than a bank as per the formula, the calculations. Very calmly and cunningly, BMC has ensured that protest does not come. You do some small wrong thing, immediately the officer comes with a big notice, I will take criminal action, blah, blah, blah. And slum dwellers invariably, I would say that even at least 50% of the slum dwellers have done unauthorized construction. No corporator or a BMC officer will even dare and go inside a slum and say that this height is illegal. 11 feet, 12 feet heights you are supposed to have, and everyone has got 1-storied, 2-storied buildings. How is it possible? 6 feet is the minimum height that is required for one person to stand. So this is what is going on, but no one has the guts in BMC to go and demolish these slums. I will say to that extent in my view. Similarly for property tax, to ensure that there is less resistance, they have not touched this particular segment. Now when we come to redevelopment, we all know that managing committee members at times are dignified estate agents of the builder. You should always get involved and don't trust your managing committee members blindly. The law stipulates that if your society is going for redevelopment, Cooperative Department has framed a circular which says that these are the guidelines which you have got to comply. It stipulates that you have to go to cooperative court if there is a dispute. It stipulates the modalities, how things have to be worked out. But when it came to High Court said nothing doing. Circular is just a formality. It is not binding. Judgment delivered by Roshan Dalvi on 8th March 2010 in the case of Harsha Cooperative Housing Society has categorically clarified that circular need not be complied with. But Cooperative Department wants its pound of flesh and they are stuck to the circular. Our Supreme Courts have held that cooperative courts don't have powers to entertain redevelopment disputes because the bylaws of a cooperative societies do not make a mention in the object clause about redevelopment, because in 60s, 70s no one thought of redevelopment. So until and unless this redevelopment bylaws are enacted, as in the object clause these bylaws are put, certainly this does not have power. And so this was the view of the Supreme Court. But what happened? Going one step forward, somehow the Bombay Municipal Corporation has issued a circular putting in their own IOD a condition that until and unless the society's cooperative department circular is followed, you cannot carry out redevelopment. Now, when there is a condition in the IOD, you cannot proceed further until that is filled. So literally builders have to get that particular permission from the cooperative department. BMC has its own ways, and one of the classic case of being the big bully is they have issued a circular that the title clearance certificate should be submitted by a solicitor. The Maharashtra Ownership Flats Act categorically states that any advocate can give a circular, give a title clearance certificate. The Advocates Act is also clear that advocates have got a right to practice, and even the Bar Council rules does not make any difference. But still, because BMC is insisting, builders normally insist for provide a certificate from a solicitor. Now talking of BMC, as I told you, BMC in my view is itself doing unauthorized construction. K West Ward, I am told there is a canteen which does not have the permission. N Ward has a weather shed which can at the most only be for a temporary few months. I am told that M West Ward itself has a room to store records which is not approved by the Bombay Municipal Corporation. Going one step forward, the registration office at Chembur, because they wanted to do renovation, they shifted to another place for more than 3 months. And I am told even that particular premises has not obtained any permission from the Bombay Municipal Corporation. When you happen to draft a letter, your drafting should not only contain the facts and figures, but these are the days when you have to dramatize your facts. If you just say that this is the problem, people won't be interested. You have to involve more people and put some pressure. And some examples pertain to the same is, if it is a matter of BMC, highlight that 27,000 crores are collected by you. In matters related to cooperative society, mention the approximate value of the flats involved, because government officers, I am told, have a big liking for big numbers, so that maybe whatever may be that reason which many of you can understand, but that that certainly helps is what my experience has been while drafting complaints. Similarly, make it a point to forward the complaint to higher senior officers. They may not even look at that particular complaint. But believe me, when they send the message downstairs, it has a good effect. I will share with you my own experience on this. One day I went to one hotel. They did not give me proper treatment. They made me wait. I had gone with my family and I was hurt because they literally made me wait for some time. Then I put my advocacy and my knowledge of advocacy. It pertains to one hotel near the airport, which has a terrace on top where food is served. So straightway I dashed off a complaint to the Prime Minister and the Civil Aviation Minister, stating that with a toy gun anyone can shoot a fully loaded plane from this hotel terrace. It's a fact. The distance is not, with a small toy gun, you can easily shoot a flat. I am not naming a particular hotel, but everyone can understand which hotel is there, where food is served on terrace. You have the beautiful view at night of planes landing, rain touching your body, and you can have good food, good drinks there. But the crux of the issue is the moment my complaint went, Prime Minister's office, I don't know what they have done, but they just directed it to Chief Secretary, please look into the matter with a copy marked to me. And in 3 or 4 days I got a letter from the owner, संपत साहब आपको तो मैं पहचानता हूँ, आप भी मेरे को पहचानते हो, चाय से कल कितनी गर्म है, मैं माफ़ी मांगता हूँ. So how you are presenting your complaint and where you are putting it is very important. It is not that we are interested in complaining, but you have to make your voice felt and you have to make the other party realize what wrong is done. For example, you are writing one letter to BMC. Along with that letter, you just ask one sentence, you write down, please give me details of all contracts given by BMC in the last 1 year for this thing, one sentence, and follow it up with RTI. You will be surprised that one sentence can hit many people, and I will not be surprised if some officer of the BMC will come and show interest in solving your complaint. I will not be surprised with that. I had such experience, so I am telling you this thing. Similarly, you always make it a point when you are writing a query to any person, ask from them the details of LAQ. LAQ stands for Legislative Assembly Questions. When this is asked, that means that officer will get a firing from his principal secretary why these big things are being brought at this small level. So this LAQ is a good tip to ask. Now let me share something with the office bearers of cooperative society present here, how they should deal with members, specifically at AGM. The first piece of advice is don't have eye contact with critic, because if you have eye contact, his tempo of asking questions and irritating you will increase. Second thing, politely tell him, normally what happens in society's meeting, there is one critic member. You speak something, he will fire some questions. You reply to him one question, he will again come out with 3 questions. And that way it will be one versus India versus Pakistan match you will find. The best way is, once you have replied to one question, politely tell that there are so many people sitting in the audience, let everyone ask one question, and if at all there is time, if time permits, we will take a second question. So that his intensity of the flow of thoughts which he has, automatically that will get subsidized, and public have got short memory. That is a fundamental rule applicable everywhere. So by the time you go to the second person, third person, his matter to some extent will get deviated and the intensity will go away. Invariably it is seen in societies that there is a group of society's office bearers and there is a group of 2-3 people who are not paying the dues. If I have it in my way, I would like to offer roses to the defaulters. As a businessman, there is a flat of 1 crore 2 CR literally mortgaged, and that poor chap is not paying you 50,000, 1 lakh rupees. He is paying you 21% interest, and you are just for that 50,000 rupees, you are going to invest that in a 9% bank, savings bank or a fixed deposit, something, 9% interest you will get. When a person is paying you 21% interest after defaulting, after literally mortgaging his flat, why should we take the curse from him? Let him remain as much defaulter as he wants. It is a good investment for us. Any member you approach, there is a tiff. The first question that may come out from his mind is, I will not pay the dues. So tell him, please don't pay it, and also tell your friends not to pay. My son and your son will sort out these issues, no difficulty at that point of time when they become office bearers. I am not here to collect the small amounts. Please don't pay money as much as you want for 1 year, 2 years, 5 years, then we will see. And believe me, in a short span of time, there is a possibility that defaulter himself would like to be a managing committee member and he will pay your dues. That possibility is very there. We should keep that matter for the next committee. Don't be impatient. Let the auditor pass remark that society should take steps to recover dues, blah, blah, blah. Let him write. It is his duty to write. Don't worry about that thing, because you are going to gain more if he is not paying. The other important thing is, when you go to consumer forum, you can always pray for ad interim injunction. And in these ad interim injunctions, you should know how to draft it so that the pressure on the opposite party becomes apparent from day one. For example, if it is a matter of builder, ask him for all details where he has paid 500 rupees and more in cash. Ask from him the various amounts he has got from investors. Ask him to give the details of the various statutory records that he is supposed to maintain. There is a big list of those things, so that he will get fed up at day one only, because chances are he has not maintained those registers. And even if he has maintained and is opening them on the first visit itself and the first 1 or 2 months of the hearing, that whole mentality of the judge will change, because all those papers are such that invariably he must not have complied with many of them. We are reading so much about the new model bylaws, elections to be held. Here, slightly shifting from my topic, I will share with you some aspects of journalism on this particular thing. The Maharashtra Cooperative Societies Act talked about no administrator to be maintained. In a cooperative society, there won't be an administrator, and people felt it is a good thing. But I am told one of the reasons for the same could be an administrator was appointed on Maharashtra State Cooperative Bank, which is financing sugar factories. So obviously the funds of sugar factories got blocked, and that in turn forced some people at the center to ensure that come what may come, in the Cold War our sugar factories should be protected. So these amendments in Cooperative Act have been brought that no administrator to be appointed, is what I am told. Here the fine print starts of the Cold War, which I am told is true. I don't care a damn whether it is true or false, but it's worth listening to these things. Point number 1, election is the backbone of any institution. In Maharashtra, approximately there are 50,000 societies. If you look at housing plus others, it may even cross more than 1 lakh. Now the law stipulates that each society's election will be done by the election officer appointed by the cooperative department. At least 5 to 10 visits will be there from this office to conduct the election in one society. Multiplied by the number of societies in Maharashtra, multiplied with the number of states in India, and what is the final output that you are going to get? A big zero. And who is going to pay for these election expenses? Obviously, the members of the society are going to pay. Those modalities have not been worked out till today, and definitely it is not going to solve anyone's interest. And see some examples of the power game, which I am told is right, and where I said journalism will come in play. Our CM earlier made a statement that more than 70,000 crores are involved in irrigation sector. It was not taken seriously. Then we got the irrigation scam, and one political party is banking very much on those irrigation projects. It may be a part and parcel of the ruling party, but its funds got blocked. Now look at Bombay Municipal Corporation, which is a very big institution itself, which has budget of more than 2-3 states of India. It is controlled by 2 political parties. How to block their funds? Very simple, no plans are passed for more than 2 years, leading to a situation where builders' funds gets blocked, where as a businessman, builder is not getting some benefit, obviously is not going to contribute to the political parties. So for 2 years we had all these things, nothing was working. Now we have read the news that cluster development is coming and 4 FSI is coming. So obviously a builder as a businessman will not mind spending some money if some projects are coming in his favor. What is the reading of mind, and who is benefiting? One political party. Other 3 opponent political parties are royally getting screwed. Their whole resource bank is getting dried up. This could be true, this could be wrong. I also mentioned journalism because one of the best newspapers of India had an office near vide station where commercial activity in the nature of Planet M were going on. The lease of that premise is expired, and when that lease got expired, to get that lease renewed, some compromises has got to be done. Now let's go to the newspaper buildings or projects in New Bombay. Practically many leading newspapers of Marathi language were allotted building in New Bombay. Very conveniently those buildings had been given to builders for development, and what happened? Big nameplate is appearing on the building, rest of the premises are being sold by builders, and some fines, I am told, have now been levied on those newspapers who were allotted building. 2 government departments having prime plots at Vashi, New Bombay. Not 2, but more than 2, I am told. Government allots, CIDCO allots these plots to some Nagaland government, Assam government or something. And we have this Kalyan Jewellers who has purchased 2 floors in that building. This plot was meant for a particular state office staff to come and stay. And what has happened? They have sold those premises to a builder who has in turn sold it to third party, and it is yours and my taxpayers' money which has been exploited. And this is what happens many times because we are quite, in all probability these things may be true what I am saying. I don't know whether they are true or false, but the point is our taxpayers' money gets misused time and again, and we are the silent sufferers. We feel that चलो अपना किसी ने 5,000 का लॉस किया है, हम धंधे में 10,000 कमा लेंगे. But these are glaring examples. New Bombay, that whole road, unauthorized construction is omnipotent. As I was talking to you was the concept of accountability. I also talked with you of FSI 4 coming. If your building is going for redevelopment, the least I will suggest you is, whatever may be the submissions, please insist on one clause which will protect you immensely, and that is 10% of the property can be sold by the builder only after he obtains the building completion certificate, and for you your flat is priceless. Before parting possession of your flat, always have the stamp duty and registration done, so that in future you get a comfort level. Your society should have an exit clause in the agreement and all expenses, be it of tax, etc., anything and everything has got to be done and paid by the builder. And lastly, I will say, life will be much more smoother and easier if we remove the clothes called ego from ourselves and try to see things from the other person's point of view. Thank you, friends.